to clarify, single digits as to the amount
A
of people
percentage.
within the firm that have that designation, but
Right.
statewide, I think it's roughly 250 in this particular practice area, but that still leaves us very limited, and several of those have retired after getting that designation. I was one of the ones that actually had to take an exam. Some of them waived in because they've been practicing so long that the state basically says you damn well better know what the hell you're talking about. So moving on, just a little bit about the firm. Caben Narembam does almost nothing except for representing community associations. So if you are happy with your attorneys, good for you. If you're not, or if you don't have one, I hope you'll reach out. We've got 25 attorneys, all focusing on this area of law. Nine, including myself, as Jeff mentioned, are board certified in this area. That means that regardless of what you think, the Florida Bar says we're experts. One board certified in construction law. This is what we do. So if you've got any questions, you need to reach out. Again, you're welcome to do so. My email is on the screen at the top of that little window, as@kbrlegal.com. And I believe Jeff will be sending that out with the survey later this afternoon or hopefully this morning if we get done quickly
Right.
enough. But I'm going to go ahead and share my screen. And as Jeff mentioned, I'm apologizing in advance if I need to go off screen for a moment. Just
We
know
know why.
that doesn't mean I don't care about y'all, but I am just trying not to cough in all of your faces. So here
Now,
we go.
Alan, one quick thing. I see a lot of
Yeah.
people in the Q&A saying they can't hear. Now, I can hear fine. I have about six people saying they can't hear anything. I will say that Zoom recently updated their applications. Even what I'm seeing is different from what I'm used to. I promise you that we have every audio setting enabled to allow y'all to do whatever you need to do, whether it's via telephone or computer. We enabled everything. So if you're having trouble with hearing things, on the lower left-hand corner of your Zoom interface is the audio settings where you can test it out. If that fails, press the captions button at the bottom of your Zoom interface. You can turn captions on, and that will work pretty well for you. I see a lot of people saying they can hear, so this is definitely a local issue with those of you who cannot. Sometimes these apps update on their own in the background and things get screwed up. Technology is technology. But again, folks, we're about to get started. Alan, back to you.
All right, thank you. So, Jeff suggested that we skip ahead and come back to the cam stuff and go straight to the condo issues. So, I'm going to go ahead and do that. Cams that are watching understand it's only a couple slides. We will come back to it, but we've got looks like over 450 on today. So,
Yeah.
we're going to take care of, no offense, but take care of the majority before what might be the minority. All right, getting into the condo materials, structural inspections. We've been hearing about this crap for the last 4 years. It's still an issue. It's not going away because let's be realistic. Legislators can't just back out of this now that they've committed to it fully and been told that they're wrong for 4 years straight and stuck to their guns. So I do think milestone inspections, as I've mentioned on several webinars and seminars, etc., are a great idea. These now apply to buildings that have a residential condo component, at least three habitable stories, as determined by the Florida Building Code. The difference here is the word habitable. So it's very clear now that if you look at what's on the screen, the bottom layer, clearly not a habitable story because it's not closed off, but your garage is not habitable. The top layer here is not habitable because it's not closed off. So we're looking at three habitable stories rather than 3 stories in height under the Florida Building Code. Um, Now, we're going to skip some of what the municipalities are required to do just to save some time, but this is also important. This is a conflict of interest here in red. A licensed architect or engineer who bids to perform a milestone inspection needs to disclose in writing to the association that they actually intend to bid on the work. So if you're saying I'm the one that's going to tell you what work needs to be done, it's kind of like I don't mean to be stereotypical, but the auto mechanic. Okay? It's the well, you need a new flange in your Flahugan. I don't know what the hell that is, but if you tell me I need it, I guess I need it. Well, if your milestone inspection report says you need a new flange in your Flahugan, now all of a sudden you have no choice but to take care of that thing. Okay, so if these architects and engineers are able to tell you you're required to get the work done, they have to disclose that they have an interest in doing the work. Now, I get the question often, what happens if we already got the bid before this law went into effect in July of 2025? My answer is the law didn't exist. They should still disclose it in advance of the bidding. As soon as that law went into effect, anyone that intended to do the work or bid on the work probably should have submitted that notification of this conflict of interest. Whether it's a violation in any way that they didn't, whether you're going to be able to get around it if they didn't within that time frame, I can't tell you. It's going to be up to the individual judge if you end up in court. Now, so we talked about the disclosure. Um, this is talking about the relationship between the firm and the association. So rather than just, hey, I did the milestone inspection, I also want to bid on the work for the architecture and engineering portion. Anyone that has a conflict of interest, just as you would have if you were on the board, within the third degree of consanguinity, which means grandparents, grandkids, second cousins, things of that nature. If that relationship exists, it needs to have been disclosed to the association in writing. And the contract is voidable and terminates when the association gives notice if the design professional or licensed contractor doesn't provide either one of these two disclosures when they're supposed to. Now, keep in mind that design professional or licensed contractor might also be subject to discipline under their statutory and um, administrative requirements if they don't disclose this relationship. Now, the important part for the association is you can also terminate the contract. That's really what matters to you guys as board members and as CAMs. We're going to skip local enforcement agencies because they're either going to do what they're supposed to do or not. And we move on to condo practices. So this is video conferences is the first thing. Now, that definition, since apparently we somehow didn't know what a video conference was, the statute now clarifies. That is a audio and video based meeting between two or more people in different locations using video enabled and audio enabled devices. Whether it would still be a video conference under this somewhat ridiculous definition, if it's only audio or only video, probably not. I can't tell you for certain. So understand we're really talking about Zoom Teams and things of that nature. The important part for the board to be aware of and the cams in the room to be aware of is that any notice for a meeting conducted by video conference needs to have a hyperlink and call-in number for the unit owners to attend. Now, it's not just the Zoom link. It's not just the Teams link. You must have a call-in number, frankly, for those who are too old to be able to figure out Zoom. Now, you guys are here today, so I'm obviously not talking about you. Don't get offended. There also needs to be a physical location where unit owners can attend in person. So here's my thought. Since this last bullet says all meetings conducted by video conference must be recorded and the recording needs to be maintained as an official record of the association, my suggestion is hold the meeting in person since you already have to have a physical location for everyone to attend and have it hybrid where you have the option of appearing by Zoom. It's not the way that the meeting's being held. You have the option to appear virtually. Now, when we talk about the video conference being recorded, understand, look at the top of the screen. We're not talking about HOAs. This is condo only. So if you're here and you're in an HOA, I'm glad you're getting the information, but we're only talking about condos for most of this seminar. Now, if you're in a condo, that video conference needs to be recorded. The recording needs to be maintained as an official record. That doesn't mean you have to actually host the video on your own website. If Zoom is recording it, you can provide the link that Zoom gives, and that is good enough as a recording that you are then sharing in your official records. Okay? You don't have to host it on your own website. That was one of the questions I got a lot early on. Hopefully everyone's figured that one out by now. What I suggest is having one Word document that you copy and paste all those links into. Once the year that you're supposed to be keeping this for hits, you just delete the links from each one of these. And you can also choose to have Zoom actually delete the video, after 1 year. Material amendments to a non-residential condo. Usually we have no one that's in one of these in our classes, but with 475 people on today, I'm going to go through it. Now even more. So the declaration of a non-residential condo that is relatively new, formed after this law took effect, it can be amended to change the configuration or size of a unit in any way, materially alter or modify appurtenances, change the proportional share of the unit owners, etc. If the record owners of all affected units and all liens join in execution. The approval of record owners of the non-affected units, meaning those whose proportionate shares not changing, etc., is not required. Now, this is important. The reason is that there is a statute that says if you're changing any of these things in a residential condominium, you need probably 100% of the members to vote unless your declaration says that a smaller percentage is required. Here, you only need the people that are affected to actually vote in a non-residential condo. So understand, we're talking about a hotel condominium, a mixed use where you've got, the portion that is not residential, or you've got a commercial office condo or something of that nature. Um, Moving on to a little bit of CAM information. If an association contracts with a CAM or a licensed management firm, they need to possess all applicable license required by the Florida statutes governing licensed managers. All directors or officers of an association that contracts with the management firm have a duty, meaning it's on the board and the officers, to ensure that that licensure exists. What I would suggest is that you actually have the management firm attaching the licensure to the contract itself. That way you don't have to worry about this. Now, if the CAM has their license suspended or revoked, or the management firm does during the term of that contract, association can terminate upon delivery of written notice to the CAM effective the date that they became unlicensed. Now, this is generally one of those, hey, that termination is basically you cut off the bleeding of what is owed to the management firm as of the date of that termination. So bottom line, managers in the Zoom today, do yourself a favor and don't have issues with your licensure, because there's going to be stuff that we talk about later that's even worse than losing your money. Insurance, every condo needs to have adequate property insurance as determined by the Florida statutes, which are, I would say, minimally clear, regardless of any requirement in the declaration for that coverage. So if you have, let's say you're supposed to have 50,000 in coverage, but your insurance agent says that under the Florida statutes, you should really have 1 million in coverage. You need to have that million now, not the 50 grand that's covered in the declaration. A group of associations can do certain things that I've never seen a group of associations actually able to do. The amount of adequate insurance is for full insurable value, replacement cost, or similar coverage. Not must, but may be based on replacement cost. So this is well, it might actually be less than you thought you needed. But that's determined by an independent insurance appraisal or an update of a previous appraisal. That replacement cost is determined at least once every 3 years. Now, this is distinct from having a milestone inspection, structural integrity inspection, blah, 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 and figuring out what your reserves need to be. This is what is your property worth in order for it to be replaced in the event of an insurable event. So understand these are different concepts. An insurance appraiser is generally going to be different from someone who can do a structural integrity reserve study, and you will need to contact your insurance agent most likely for this to happen. The obligation to obtain and provide adequate property insurance coverage for a group is a pain in the butt, so we won't go through it. And I say that a little bit facetiously, but the reality is the requirements to provide group coverage are so egregious that every time I've had a client ask me what's required for it, after I put out the first 1 or 2 requirements, they stop reading according to what they had told me because it's just not feasible. Now, there are a bunch of official records that are now officially included in the official records. I'm not going to go through this because you've already got the catch-all that anything that's not specifically stated in the official record statute that is pertaining to the operation of the condominium and is in writing is already an official record. So we don't need to go through these in detail. Feel welcome to read through it when you get the slides later. One of the things that is important, another few items need to be kept adequate copies. Again, the statute still doesn't clarify what an adequate number of copies is. That'll really be dictated by how many people come into your office asking for a copy. But the association needs to keep your Q&A sheet on property, your most recent annual financial statement, and the annual budget. All of that now needs to be kept on property. What I suggest is having a printed copy in a binder at the association property somewhere of all of the things that you're required to have adequate copies of. And that's really the governing documents in these items and maybe one or two more things. But if you have a physical printed copy, you can even put how much it'll cost for an owner to take those copies with them. And then, if they pay that cost, good, have at it. Here you go. And then the association just prints out another copy of each document that the owner took. A director or member of the board or association who willfully and knowingly or intentionally violates official records inspection requirements, meaning you refuse to produce records upon request. It is now a violation. It's a misdemeanor. You're removed from office. It is a crime to knowingly and intentionally not produce records. Bottom line, just give them up. Now, if your attorney tells you that it's appropriate not to give it up because there are many exemptions in the statute that say, hey, you don't have to give attorney-client privileged information or certain direct contact or personal information of the individuals who own units in your condo, fine. Okay, but get that advice from counsel because if not, you're risking a misdemeanor, not just a lawsuit against the association at this point. There's no longer a requirement that that happen 2 times in a calendar year. It is literally, if it happens at all, you've committed a misdemeanor and you can be prosecuted for it. Don't fall into that trap. The official records that now need to be posted on your website if you are required to have one. And by the way, look at the reminder in red here. If you are in a condo with 25 or more units, you now need a website. It used to be 150, it's now 25. So 90% of condos in Florida now need to have a website. The good news is if you're working with a management firm, almost every management firm's portal actually functions as that website. It's just a matter of making sure that the documents you're supposed to post there are actually uploaded. But again, the additional requirements to post on the website, your approved board meeting minutes for the last 12 months, the video recording or hyperlink, as I mentioned, to all video recordings of meetings of the association, the board, committees, or unit owners, and a copy of all affidavits that the entire Chapter 718, all 100 something pages of it, require. That includes literally every mailing that you do. It includes the affidavits pertaining to, in my opinion, notices of late assessment. So everything, every affidavit now needs to go on the website. Financial reports, the good news here, you were previously given up to 120 days, 4 months, to produce your financial report at the end of the year. If you were handing it off to someone else, like a CPA, to prepare, you now have 180 days, which is roughly 6 months. So you have additional time to produce those records. Um, Now, a copy of the most recent report or a notice that a copy is available upon request needs to be sent out. So the good news is you now no longer have to officially mail it out. You can use a postcard just like you would for a lot of other things. That needs to be done within 5 business days after receipt of a written request. You provide the records. So it's kind of like a records inspection, but you're not charging and you are sending it within 5 business days, not 10.
Alan, I got to interrupt. Folks, the chat, remember the chat module is for technical questions or confusion questions about who gets what kind of credit, questions I can answer. Class related questions, course material, stuff Alan is covering. Again, please use the Q&A module, 2 different modules. So any questions that were placed into the chat that are based on the course material are not going to get answered. Uh, Put them in the Q&A. There's a better chance they'll get answered there. But again, the chat is not for class related questions on the course content. That should be in the Q&A module. And at the end, Alan will get to as many as he can with the time left and if his voice allows it. Back to you.
And candidly, we will have a lot of time because although the legislature did take a bunch of action this year, they left HOAs out of the mix. So I suspect that, we account for 2 hours here. I'd be surprised if I take more than an hour to go through the materials. So there will be plenty of time for Q&A at the end. Now, getting back to what we were talking about, these financial reports, this is a new requirement. Evidence of compliance with delivering the financial report must be made by an affidavit. That was already required, but the affidavit needs to be executed by an officer or director. Note who is missing from that list. This can't be signed by the manager. Now, that makes no sense to me because let's be realistic, the person sending it out is going to be the manager. And I don't know how you're supposed to have an affidavit that someone else sent something out because you can't attest to it unless you are physically present when that is happening. If you're able to do that, great. What I would suggest is that you draft the affidavit 100% accurately because keep in mind, that is your written testimony. That's what an affidavit is. So you are attesting to the fact that this is what happened. Um, Another slight change, if a majority of all voting interests of the association approve it, you can prepare an alternate report in lieu of a compiled, reviewed, or audited financial statement. So that is a majority of all voting interests, not a majority of everyone that actually shows up where there's a quorum. Investing association funds, I know you'll all be shocked by this, but the board is required to make its best efforts to make prudent investment decisions. Thank you, legislature, for making that clear. I think someone just wanted their name on a bill on this one. I don't really understand why we needed to put that in writing. That fiduciary duty already existed, but okay. An association, including multi-condos, can invest reserve funds in one or any combination, and this is a change of certificates of deposit so that's a CD for those that don't know what a CD is, or in depository accounts at a community bank, savings bank, commercial bank, savings and loan, or a credit union without a unit owner vote. So the board gets to decide where then how that money is invested within these categories. It's not you throw it in the stock market, it's not you take it to the track. Okay? It's these are the places that you're allowed to put the money. And all right, I'm not going to make the It's a Wonderful Life joke about the savings and loan, but we'll move on. Hopefully, you guys can picture that in your head. Board meetings now can be conducted in person or by video conference. The division must, but hasn't. And we're now 7 months after this law went into place saying the division must do something, but they need to adopt rules governing the requirements for board meetings. The notice. If you're holding it by video conference, I mentioned earlier, it needs to say it's by video conference, include the link and phone number for owners to attend, and the address of the physical location where they can attend anyway. Again, I think it makes more sense to schedule it in person so that your requirements are slightly less, or at least they might be. Video conferences need to be recorded. We already went through that. Unit owner meetings. If the bylaws don't provide the location, it used to be you could hold it within 45 miles of the community. That is now 15 miles. So if you were holding your meetings at the management office and the management office is more than 15 miles away, it's time to find a new location. Okay, I know some communities are holding it at churches, schools, things like that. That school gym, if it's not within 15 miles, is no longer an appropriate location for that meeting. So make sure you are watching out for where that meeting can be held. You can hold unit owner meetings in person or by video, just like board meetings. Same deal if you're holding it by video conference. You need to record that. More importantly, a quorum of the board must be physically present at the physical location where unit owners can attend. Now, I think that's a little crazy because if everyone else can attend by Zoom, I don't understand why the directors can't. Which again, I would do the same thing as I mentioned earlier for board meetings, hold it in person. That way, those directors technically are allowed to attend by Zoom. But keep in mind, what this means is if you hold your meeting by Zoom, and I use Zoom as the example just so I'm not saying Zoom Teams, etc. 50,000 times. But if you're holding that meeting by Zoom and a quorum of the board is not in attendance, technically you can't hold the meeting according to this new law. So I think it's a bad idea to do it that way because, frankly, let's say you've got a 3-member board. 2 of them really want to stay on the board. All they have to do to make that happen is not show up at the meeting because then you can't have a meeting unless you've got, your quorum and blah, blah, blah. So bottom line, I suggest, even if you're using electronic voting, that you hold your meeting in person with a virtual option. Um, so same recording requirements, etc. Unit owners can vote electronically. We'll get into the awful news about electronic voting in a little bit. Again, division needs to adopt rules. Again, they have failed to do so after 7 months. Broadcasting, I don't know that anyone really uses, but it's no longer an alternative to physically posting meeting notices. So if this is something you were one of the last few in the state that was doing, you got to stop, or at least stop using it as what you're relying on. You can still broadcast notice, but you also need to post. Your budget meeting. So the budget meeting needs can be conducted by video, and the division must adopt rules that they haven't adopted yet. A sound transmitting device needs to be used so that the conversation of members can be heard by the board or committee members attending in person and by anyone present at the meeting, including by Zoom. Now, I don't know why this had to be in the statute because it applies to every meeting that's being held virtually. You need to be able to hear what is going on. That is the whole purpose of being allowed to attend electronically. Now, the 115% rule is one that everyone seems to misconstrue, but it's changed this year, so we're going to go through it briefly. If the board proposes a budget which requires assessments that exceed 115% of last year's budget, the board needs to simultaneously propose an alternative budget that removes anything that is discretionary. Now, I don't know why you would have discretionary expenditures in the budget in the first place. I don't know how this is feasible, but okay, if you were planning on doing a landscaping project that isn't absolutely necessary, I guess that's discretionary. But your whole purpose of having a budget is to include everything that you need to do next year. So I don't know how this comes into play. I guess we'll see how it plays out. I haven't had anyone ask me about it throughout the course of the 7, 8 months that this has been in play. And the other thing to understand, there were a few categories of items that don't count towards this 115%. There is now more. Okay, what doesn't count towards the 115% increase? Any reserves for repair or replacement of the condo property, so any reserves, structural integrity reserves as well, and insurance premiums. So your insurance premium and your reserves are generally going to be two of your biggest ticket items, other than maybe your landscaping bill. I mean, it should be your attorney's fees, but hey, what do you want from me? But uh, but the reality is, if you take your reserves and your insurance out of the equation altogether, I rarely see anyone increasing the budget by that much. Most of the time, when you need to increase the budget by 115% year over year, it's because those two categories of items skyrocketed. Even if that happens now, you don't need to do the alternative budget. All right, moving on. Um, and so when you do propose these two alternative budgets, the substitute budget requires a majority of all voting interests unless a higher percentage is required by the bylaws. If that substitute budget's not adopted, meaning no one cares enough to show up at the meeting and no one votes to say, we want this lower budget, you go with whichever budget the board wanted. And that should be the one, frankly, that's higher, because otherwise, why the hell would you have to do the alternatives? At least 14 days before a budget meeting in which a substitute budget is going to be proposed, the board needs to hand deliver or mail to each unit owner a notice of the meeting, or longer notices. Like, I have some communities that have 30 days for a budget meeting in the bylaws. You'll need to follow that timeline. Reserves. This is actually a good one. So for budgets adopted on or after December 31st, 2024, you can't provide no reserves or less reserves than required by the little g items, meaning your structural reserves, except that members of an association operating a multi-condo, this was added, can determine to provide no reserves or less than required. If an alternative funding method has been approved by the division, not just we're proposing an alternative funding method, but one's actually been approved. I haven't seen that really happen yet. So chances are you still need to provide your structural reserves. Now, I said here's the good news. This is it right here in red. You used to have a $10,000, hey, if this is going to impact any of your structure of your building, and it's going to cost more than 10 grand to do the replacement or repairs or deferred maintenance in the future, that was now a structural reserve. That dollar figure has now crept up to 25 grand. And the division is supposed to update that number, increase it every year. It was supposed to happen February 1st. I haven't heard that it's happened yet. Maybe I missed that announcement by DBPR. But the bottom line is this is supposed to increase every year, and it's going to be 25,000 plus whatever the DBPR decides. So you don't have to have as many reserves. That might mean that what you had in your SERS needs to be modified. Hopefully, you've got a contract that that's going to be done on an expedited and lower dollar figure basis. But if you need, I mean, you can still keep what's in your existing SERS, but if you want to put away less every year and have certain required reserves disappear or at least become non-mandatory, this is something that you can reach out to whoever prepared your structural integrity reserve study, and you might be able to remove or at least convert some of those mandatory reserves into things that you can vote to not put the money away for. Membership approval is no longer required to pause reserve contributions if the local building official says your condo building is uninhabitable due to a natural emergency. Now, this is not just you have a problem with your building, you can't live there. This is there was a hurricane, you can't live there because of COVID. It's due to a natural emergency in particular. So I have a lot of people misunderstanding that piece or at least missing that piece of how this works. Reserve accounts can be pulled for two or more required components, but reserve funding for SERS components can only be pulled with other SERS components. And that makes sense because otherwise you're using the funds for non-SERS reserves that you shouldn't be using because you're required to put this money away specifically for your SERS reserves. So you can pool your reserve accounts, but you have to have two pools. Reserve funding indicated in the proposed annual budget needs to be sufficient to ensure that available funds are enough. So you can't have less than zero in your reserves at any time. And a vote of the membership isn't required for the board to change from pooling to straight line or straight line to pooling. This is good news, but I have some concern as to how you're supposed to actually move the funds themselves. Because technically, if you're moving from a straight line to a pool, you are almost guaranteeing that some of the funds that were in the straight line are going to be used for other assets of the association, which requires a member vote. So be careful. I would get guidance from your attorney. But generally speaking, the board gets to decide which method to use. It's just a matter of if you want to move the funds. Now, there's nothing that says you have to move the funds. You can just use up what's there and then shut down that particular reserve if you choose to do it that way. If an association votes to terminate the condo, the members can vote to waive SERS. That kind of makes sense. If you're going to have no condo anymore, why the hell do you have to put money away for a building that in 15 years will need that money? Why should I be required to pay if 6 months to a year from now, I'm not going to be a unit owner anymore because there won't be a condo anymore? So I think the legislature made the right call here. Serves reserves, this is a new one. There are different options for how to fund them. So your SERS reserves in particular can be funded by regular assessments, which was the only option before, but now also special assessments, lines of credit, or loans. Special assessment line of credit or loan requires approval of a majority vote of the total voting interest of the association. Now, this highlighted portion is problematic because what the heck are you supposed to do if your declaration or bylaws say that the board has the unilateral authority to get that line of credit or loan? Now, all of a sudden, you've got a statute that says, yeah, I don't care. You need a member vote. Well, we need to have this money. How are we supposed to go out and get it if the members can avoid the need or the ability of the association to do this by simply not showing up to vote? There's really not a legislative solution for this yet. So just understand you might be stuck doing a special assessment. You might be stuck shoving this into an amended budget so that it goes into your regular assessments. And I've had some clients that strategically we've suggested that they point out, listen, we've got 4 options of how we can fund this. If you ignore us and you don't show up and vote, when we're asking you for the authority to do it in a way that doesn't require you to put all this money in this year, you will have to put the money in this year. And if you choose not to pay the increased assessments that will have no choice under the law but to levy against your units, and if you don't pay, you might be foreclosed. And frankly, the board doesn't want to have to pay this all up front either. That's why we would like to get a loan or a line of credit. So a lot of it is about the way that you phrase these things, not about what you can and can't do. Um, excuse me. The special assessment line of credit or loan does need to be disclosed in the annual financial statements as well. Now, a unit or a controlled association that needs a CERS can secure a line of credit or a loan to fund capital expenses that are required by a milestone inspection or a CERS. If you're developer controlled, you haven't turned over for at least a year, or you're controlled by one or more bulk assigntees or bulk buyers, you don't have that right. Okay, so it's you can do this unless you're one of those types of organizations, so to speak. And that's because the legislature doesn't want developers or people that are like developers to be able to avoid the need to actually put this money away. Now, the line of credit or loan must be sufficient to fund the full amount of any previously waived or unfunded portions of the reserves. In other words, if you didn't fund your reserves for the last 5 years and now you're trying to do it by getting a line of credit, the line of credit, excuse me, needs to cover all of the back pay, so to speak, and everything you'll need going forward. Funding needs to be available immediately, not, hey, we can submit a request and we get our money in 6 weeks. No, the money is, we pull it out of the bank tomorrow. For a budget adopted on or before December 31st, 2028. So we've still got some time for this. If the association completed their milestone inspection within the last 2 calendar years, so meaning this year or next year, well, not necessarily, but generally this year or next year through 2028, upon the approval of a majority of all voting interests, the board can temporarily pause for a period of no more than 2 years, reserve contributions, or reduce the amount of reserves for the purpose of funding the repairs. In other words, if you've got a whole bunch of work that your milestone inspection,
Yeah, hang in there,
excuse me.
folks. Now, while Alan's doing that, just a quick reminder to everybody that Alan will let you know once all of the condo material has been covered. We're coming up on that shortly. In a little bit, we'll have a lot of that ready. When Alan says the condo portion is over, if you're a condo board member, after you submit the evaluation, I'm about to place the link into the chat, you'll be able to fill out the evaluation and you can leave if you choose to. CAMs must stay on the entire time to receive their 2 credits. Okay, so again, I'm about to put the link into the chat for the evaluation, but that does not mean you can leave right now. Condo board members, again, I'm reiterating, so everybody please pay attention. Condo board members, once Alan says the condo portion is completed, you'll click the link, fill the evaluation, and again, if you want to, you can go. But if you're a manager looking for CAM credit, you must stay on for the duration of the rest of the class. Alan, back to you.
Thanks, Jeff. All right, so what I was trying to say before I had a coughing fit, in plain English, if you have a bunch of work you need to do on your buildings, you're allowed to pause your reserves and use that money for the work that needs to be done. That can be done for up to 2 years in these circumstances. This doesn't apply again to those developer controlled communities because the developer presumably has the money to just get the work done. Whether that's accurate or not may be questionable. And if you've paused the reserve contributions, you need a new CERS before you can just continue the structural reserves that you had planned before, because presumably the value and the required input of dollars is going to be different based on the fact that you've had the work done. Residential condos must have a CERS completed at least every 10 years for each building on the condo property. Here's the change. That is at least 3 habitable stories, just like in milestone inspections. CERS must now include any item, again, $25,000 or greater, that impacts the actual structure of the building. And again, that will be increased annually, we hope. The CERS needs to be performed by a licensed engineer architect or a person certified as a reserve specialist. It needs to include, and that's not changed, by the way. That's what was here. The big change is it needs to be based on a baseline funding plan that never has a zero balance. The balance always needs to be for every component, or at least for the entire pool if you're pooling, it has to be above zero at all times. So you can never have a zero balance on any reserve category or reserve item. Can recommend other types of reserve funding schedules if each recommended schedule is sufficient to meet the association's maintenance obligations. Those are generally determined by the declaration. So I can't tell you what those maintenance obligations are. That's going to require a review of your governing documents. The SERS recommends, if the SERS recommends reserves for anything that's not a SERS component, the statement now needs to be made that it is not a SERS component. The reason that's important is because the association needs to be able to know what is an absolute mandatory, you must put this money away, as compared to what is a, you can get a member vote to not fund this particular component this year or maybe next year. So that now needs to be outlined very specifically in the SERS itself. It needs to consider the funding method or methods used to actually bring the money about to pay for your SERS. I'm not your SERS, your actual reserves, your structural reserves. If it's done before you have an approved special assessment or secured loan or line of credit, it needs to be updated to reflect that funding method once you get it approved and how it affects the funding schedule, etc. So basically, if you change the way you're funding or you haven't finalized the way you're funding, you need to update the SERS afterwards. So make sure that your contract with the engineer, architect, or reserve analyst actually says that they're going to update this as needed, either at a reduced rate or at no charge when these things happen. Because otherwise, you're basically paying for a new one or paying a significant premium to have the work done. Now, understand most of them understand that they shouldn't be doing a complete new one and should just be updating the SERS when this happens. Hopefully, everyone is. I can't guarantee that though. So make sure that you're not just having a new SERS every time it changes, because that would be an absurd and unnecessary cost. You do need an updated SERS before adopting a budget where the reserve funding from regular, special lines of credit or loans doesn't line up. So you can't just unilaterally decide, hey, we had a bunch of work done, so we're going to put less money away this year. You have to actually get the SERS updated. SERS is not required for four family dwellings with three or fewer habitable stories above ground. It was already one, two, or three family dwellings. Now it's four as well. And associations existing on or before July 1st, 2022 must have the SERS done by December 31st, 2025. That's already passed. It was December 31st, 2024, and now it's 2025. So either way, you were required to have this done if your building existed or your association existed more accurately before July 1st of 2022. If you complete the milestone inspection or a similar inspection, you can delay performance of the SERS for up to 2 consecutive budget years after that to allow you to focus on the financial resources to complete the repairs, as we mentioned earlier. An officer or director, again, not the manager, needs to sign an affidavit acknowledging receipt of a completed SERS report. And again, another rule that division was supposed to adopt regarding the form of the SERS that I don't believe they've adopted. Anyone who bids to perform a SERS, just like a milestone inspection, is required to disclose the intent to bid in advance. So we talked about the conflicts on milestone inspections. Works the same on SERS, so we can skip the rest of this slide. Hurricane protection is a completely separate topic, so we'll kind of start fresh here. Unless otherwise provided in the declaration, a unit owner is not responsible for the cost of removing or reinstalling hurricane protection, including exterior windows, doors, or other openings, if the removal is necessary for the maintenance, repair, or replacement of something the association is responsible to maintain. So, what does this mean? If you are maintaining your buildings, you're repainting, and to do that, you have to pull all of these hurricane shutters off. You now have an obligation at an association expense to reinstall them unless the governing documents say otherwise. Now, note the words as amended. This could be an amendment that the board decides to make, to say that, yes, we'll do the work and we're gonna be the one charged for it, but we're gonna charge it back to the owners as an owner expense because you chose to have hurricane shutters instead of, let's say, hurricane protective glass, for example. Okay. So that would need to be in the declaration. Otherwise, the association's responsible if the association's the one doing work. If the owner's doing work, then this is all on them. The board needs to determine whether the removal or reinstallation of hurricane protection must be completed by the unit owner or the association if the declaration doesn't specify. So that means, for all practical purposes, at that point, it is up to the board who's responsible if the declaration is not clear. Now, that is who's doing the work for the removal or reinstallation of the hurricane protection. Now, who's responsible financially is clear from that first bullet. So these are two separate concepts that are very interrelated. If there is an evacuation in the event of a hurricane or some other type of event in the location where the condo is located, the board can require evacuation. Now, they're not physically removing you from the condo, but if you don't leave after that evacuation order comes through from the board, the association's not responsible for any liability for injury to persons or property that arises from the failure to get the hell out of Dodge. So understand that means that you're putting out the word, everyone has to go, and if people choose not to anyway, that's on them. Electronic voting. So, good news, you don't need a 14-day notice of a board meeting to adopt electronic voting. That is now a typical 48-hour posted notice, just like any other board meeting. Now, this is new. If at least 25% of the voting interest of the condo petition the board to adopt a resolution to use electronic voting for the next scheduled election, not permanently, but the next one, the board must hold a meeting within 21 days after receiving that petition to adopt the resolution if the petition is received within 180 days after the date of the last scheduled annual meeting. What does this mean? 6 months after an election, the members can band together and have a petition that says, we want electronic voting. I don't understand what the hell's wrong with you, board of directors, in not allowing us to do this anyway. So we're going to try and force you to do it. Now, the board must hold the meeting to adopt the resolution. I don't know, and you'd have to consult with your own individual community association attorney. This doesn't necessarily say that you have to actually adopt electronic voting. I would say do it anyway, and we'll get into why in just a minute. But I don't know that even if the petition is received, it's appropriate, you hold the meeting, whether you need to actually adopt the resolution. You're holding the meeting for the purpose of discussing the resolution. I would have to, I would have to defer to your counsel as to whether you have the obligation to adopt electronic voting if people ask for it. But I would do it anyway, and here's why. Jeff, you got something to add?
Just a quick thing. We're getting into that habit again, folks. I'm going to reiterate the chat and Q&A modules are two different things. Please place course-related questions into the Q&A module, not in the module that says webinar chat. Do not put class-related questions into the webinar chat. Put it in Q&A. If you don't see the Q&A, once again, there's a button at the bottom of your Zoom interface. Press the Q&A button one time, then that module appears. Alan, back to you.
And I'll point out, in addition to getting in the way when Jeff is trying to answer those technical questions, I'm also not going to look at the chat to answer the Q&A. So your question's not getting answered if that's where it's located. So make sure that you are posting in the right place. All right. Now, I mentioned I think that everyone in a condo should be adopting electronic voting. This is the reason. So this is distinct from electronic voting. It's electronic ballots. Unless you adopt electronic voting, which is the way to avoid this garbage, the association needs to do a couple things. Okay, the most important one is you need to create an email address that is specifically used for receiving electronically transmitted ballots. What does this mean? Email ballots. Okay, the unit owner can electronically transmit the ballot to that email address without complying with rules providing for secrecy of ballots. That's fine with me. They're waiving their anonymity. I'm okay with it. But the association must count completed ballots that are electronically emailed over, so long as the completed ballot includes a space for the unit owner to type their unit number, a space for the unit owner to type their signature, not sign, but just type the name, which functions as the signature, and use this statement in capitalized letters and in a font size larger than blah, blah, blah. So you're preparing this different ballot for unit owners to use, and they get to submit it via email. Now, what's the problem with this? I can submit 30 ballots for all I care. There's no requirement or ability, because you must accept it, to actually verify that the person submitting the ballot or that the email address they're sending it from is actually even a unit owner, or that they have a proxy if they're voting on behalf of somebody else. It's literally just, if they submit it, you have to accept it. Now, if someone votes 5 different times, you can still discard their ballot like you normally would be if they submitted 5 paper ballots, unless they have 5 units. But this is basically the legislature begging for fraud, in my opinion. There's zero verification whatsoever that the person submitting the ballot actually had the right to vote. Other than that, the unit had the right to vote and that the right name is on there. Now, obviously, anyone that's submitting a fraudulent ballot is committing election fraud. That's a separate issue, but it will throw off your election if you have someone doing this the wrong way. Again, my recommendation is avoid this at all costs. Adopt electronic voting, find a good electronic voting vendor, and you won't have to deal with this at all, because it's only required if you're not using electronic voting. When you are using electronic voting, the owner must transmit their completed ballot to the email address designated by the association by the scheduled time and date. Or actually, this is the email voting still, I'm sorry. And a rebuttable presumption that the association reviewed all folders associated with the email address, meaning you found all the ballots that were submitted, is done by sworn affidavit of the manager attesting that you actually reviewed all these folders. So not only do you need to actually provide the email address, but you need to review every single folder, including whatever spam may come in over the course of the year. And if someone decides to submit 500 spam messages, that's not election fraud. It's just obnoxious. So now you have to review all 500 emails to make sure that none of them pertain to the election, and then you have to sign an affidavit saying you did so. Again, use electronic voting, avoid this altogether at all costs. I don't anticipate we have any non-residential condos with 10 or fewer units in here. I represent literally one at this point, so we're going to skip that, but you'll have the slide if you need it. Condos created within a portion of a building or within a multiple parcel building within 60 days after the end of the fiscal year. This is talking about your apportionment of expenses. So the owner of a portion of a building that's not subject to condo ownership must provide the association a complete financial report of all of the expenses that they're trying to pass along to the residential condo. That report needs to include copies of all receipts and invoices, and if they don't provide it within 60 days, the division can impose penalties and otherwise enforce and ensure compliance. That doesn't mean, unfortunately, that the residential association doesn't owe the money. It just means that they get penalized. So the state gets some money, which is hugely beneficial to the residential condo, right? Wrong. Now, within 60 days, after you receive this information, you need to also challenge any apportionment of costs, or you lose the right to challenge it. So you only have 60 days after you receive it to look through all those records and challenge any of the individual costs that they're trying to pass along to you. So make sure that if you get that report, you follow through on it immediately. Take a look at it, get it to counsel if you want counsel to raise the challenge, etc. Division has expanded authority to address milestone inspections, repairs required by milestone inspections, insurance requirements, condo board member education, and reporting requirements for CEUs. Hopefully everyone's done this because it's been required for 5 months now. Every condo needs to create and maintain an online account with the division, provide the information requested by the division, update it within 30 days after any changes in that information, and the division does need to provide a condo at least 45 days notice if you haven't complied with these requirements. So hopefully anyone that's required to do this that didn't do it by October 1st when it was required has already gotten that notice and taken care of it. The other thing I'll point out is when you're doing this and submitting information, usually I believe it's only when you're submitting information on whether you've completed your CEUs they're actually asking for a copy. You do not have any obligation whatsoever to provide that copy to DBPR. So you can just check off that you did it. That's all you're required to do. Here's just the information that the online account needs to include. And again, a copy of any CEUs and associated materials within 5 business days following a request by the division. So that means you don't need to upload it up front. If they ask for it, you do have to give it to them. Some communities are choosing to just do it so they don't get that request. Up to you how and whether you do it. You can just report that you've completed it and the date that you completed your requirements on instead. My Safe Florida Condo program is still condo-ish. This is a great program. Unfortunately, the funds are up yet again within like I think a week or two after the funds became available. But this is a program. It's still technically a pilot program, even though this is year two. It essentially gives money to the association to either look into what it would take to better shore up the condo buildings or actually do the work to better shore up the condo buildings. It's generally going to require a member vote. It's a $1 spent by, I think, the association to $2 received from the government. And this is really just to better protect our buildings from hurricanes. I'm not going to go through it in detail. You can read through all this. Some changes have been made, but only 75% of the unit owners need to actually approve the application. So you don't have to go and get everyone to sign off in order to ask for this government funding. And I'm a libertarian. I think that the government should be paying for very little, but I think this is a very good and important benefit to the state. And I like the fact that the funds are frankly limited because that means less is coming out of my taxes and I'm paying less. All right, moving on. Timeshare plan management, we're going to skip. Administrative procedures, you are not going to have to comply with because it's for the administrative actions. Education and correctional facilities, I don't get. Flood disclosures, this is generally for anyone that is selling or developing or renting land. Detailed flood risk information needs to be given. This is something that, frankly, if you are renting, selling, or developing a community, run it by your attorney rather than relying on 3 slide or 1 slide in a webinar. Now, this says we're done, but don't forget we did
Yeah.
condo first. So we're going to jump back to CAM stuff now. Jeff, you got anything you want to add?
I'm just going to reiterate right now that condo board members, I'm going to place the link into the chat right now. Again, it's been in there a couple of times already. But if you're a condo board member, you're welcome to hang on and hang out and stay and listen to the rest. But if you're here solely for your condo annual CEU, continuing education unit, the one you need a year, you can fill out the evaluation and you're able to go if you want to. Managers, you're welcome to fill out the evaluation now as well, get the slides, the whole 9 yards. But we do check the Zoom timestamps, and managers for your 2 CEUs, you must stay on until the end and also have been here from the beginning, obviously.
And before anyone leaves, Jeff, I will point out that you're not going to get any of the Q&A and
Right.
any of your questions that you've posted if you are in a condo. You won't get the answers if you decide to dip out. It'll only be another 5, 10 minutes when I'm going through the management stuff. So I would suggest that you stick around, but as Jeff mentioned, if you choose not to, that's your prerogative.
All right. And so again, questions about credits and CEUs and things of that sort, certificates, that's what you ask me in the chat. Again, course-related questions in the Q&A module. They're two different things. Alan, back to you.
All right, so moving on to managers and management firms, new penalties for license revocation. So bottom line, if you're a CAM or a management firm, make sure you do what you're required to do because if you get a ding and you get suspended, that is for 10 years. If you lose your licensure, you cannot reapply to be licensed as a CAM for a decade. That is find a new job, find a new career territory. So bottom line, do not do anything that would get your license revoked. I know that is a little bit fatalistic, but apparently the legislature is taking this stuff extremely seriously. So make sure that you're doing what you're required to do, not only under your contract, but almost more importantly, although for me it's more important that you follow the contract because I represent the associations, but almost more importantly, follow what is required by the CAM statutes as well as DBPR. CAMs and management firms, just like condos, need to maintain an account with the DBPR. You need to create and maintain that licensure. Again, you've got 30 days to change the information if it changes. The CAMs need to identify the management firm they work for and identify which associations you work for as the designated on-site CAM. Now, if you're not the designated on-site CAM, I would run it by your own management firm counsel as to whether a portfolio manager actually needs to make these designations. You're not on site. So I don't know offhand whether this applies to you or not. The management firm also needs to identify what CAMs it employs. And again, if the license is suspended or revoked, the department needs to notify both the management firm and the associations for which the CAM performs management services that that license has been suspended or revoked. Now, a suspension is different from a revocation. Suspension means you come back. Revocation means you've got 10 years that you're out. All right, professional standards. You can't knowingly perform any act as a CAM that is directed by the association, even, meaning you might be violating your contract, but you won't be violating the law if that act violates any state or federal law. Not it violates the declaration, although arguably any violation of the declaration is a violation of state law because chapter 720, I think it's sub 305 and 718 303 both say that, you are not allowed to violate the declaration. So any violation, you can't do it. So if you disagree with what the board is telling you, you might have to tell them, sorry, but I can't do this. I know it's wrong. It is a knowing violation of Florida law, and I can't do it, so I won't do it. I know that that might put you guys in a bit of a bind, but this is what you're now required to do under Florida law. If the management firm or CAM has a contract with an association that's subject to milestone inspections or CERS requirements, the manager or CAM firm must comply with those requirements as directed by the board. So it's not just you need to do what you're supposed to do, it's you just take board direction on that. Each contract between the association and manager or management firm needs to include a new statement in at least 12-point type if it applies. And that's that you need to follow your licensure requirements in Chapter 468 of the Florida statutes. And contracts between managers or management firms and the association can't waive or limit any of the professional practice standards required by Chapter 468, meaning you can't just say, well, I'm not required to follow my legal requirements. That's not part of the contract anymore. That is explicitly now part of your contract, following what the statute requires of a management firm or a manager. There is a new obligation of managers, and this previously applied only to HOAs. It's now condos and cooperatives as well. You need to basically attend, well, not basically, you need to attend at least one association meeting per year. Now, the good news is the statute doesn't say attend in person. It just says attend. So my perspective is if you're on Zoom once a year, you've got that covered. I don't know of any management agreement that doesn't require you to do that anyway. So this shouldn't be too egregious. You need to provide the members of the association and post on the website, if otherwise required, the name and contact information for the CAM, which you were already probably doing, and provide to any member upon request a copy of the contract between the association and the management firm. Now, keep in mind that contract, you're talking about the management agreement itself. That is not a records inspection request, just like I said to HOAs last year. This is a separate request. It is not the association that's going to be responsible for damages and attorney's fees and costs. If this doesn't get done and you don't produce the record upon request, it's going to be the CAM or the management firm. So make sure that you're taking care of this. My suggestion, if you're a portfolio manager, keep all those in a folder on your desktop, all your management agreements, so that you can produce them upon request. Same thing if you're an on-site, keep just the management agreement on your desktop so that that's readily available and you don't have to worry about whether or not you can find it in the official records. And by the way, if you can't find it in the official records, you might want to think about that too. Conflicts of interest, it's now a rebuttable presumption, just like a director doing business with the association, the management firm, same deal. In lieu of listing the entities that might do business with the association, Reference is now made to persons that might do business. That includes a lot of other individuals, entities, etc. And the term compensation is also defined. And if you can't figure out what compensation means, you probably shouldn't be managing a community. The way to avoid this major issue is my suggestion: provide a list of all entities that are affiliated with the management firm or the manager. Make that part of your standard contract as an addendum so that you are explicitly disclosing here are the other individuals or entities that we might ask to do business with the association. This usually will pop up when you've got an affiliated maintenance company where you've got the management firm actually has maintenance staff that they can send out, but it's done through a separate company. If it's not for the management services, even if it's through the same management firm company, this needs to be disclosed. So again, just have a list that you keep that gets attached to every contract. If you haven't done it as part of your contract up front because it wasn't required until July of last year, do it as an addendum, but get something in writing that makes it very clear we have disclosed all this information before asking to do business with the association. If you're already doing business with the association, my suggestion on behalf of management firms is to get that information out there in an addendum that acknowledges, listen, we were aware of the conflict when we signed on with this separate entity. We're not raising the conflict as a basis to terminate the agreement, blah, 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 because otherwise, technically, if you didn't disclose it in advance, the association might have the ability to terminate that contract now, even though you've been contracting and working with the association for some time. Anytime the association considers a bid exceeding $2,500 for goods or services other than management services, which is a conflict of interest or might reasonably be construed to be a conflict, the association needs to solicit multiple bids. That doesn't apply if you've attached that sheet outlining all of these entities to your contract itself. So that's why I suggest that you just do it. Then, if the association wants to work with the management firm, you don't need to get those bids. If you propose to engage in an activity that's a conflict under the statute, it needs to be listed on the meeting agenda of the next board meeting. The meeting notice also needs to describe the proposed activity, disclose the conflict, and include a copy of all of the contracts and transactional documents related to the proposed activity, including those related to the conflict itself. If the board finds that a manager or a management firm has violated this conflict of interest disclosure, you have the same thing that you have with a lot of other opportunities. The association can terminate the contract by delivering written notice. Note that this one doesn't require a member vote. It's just the board finds out, hey, there's a conflict. They send you a notice. Contract is terminated, including the management contract. So bottom line, don't screw this up because it's just like everything else. You'll only get paid through the date of the termination, regardless of any termination fee that you otherwise had in your contract. So don't make that mistake. And now I can officially say that we've gotten through all the slides. I promised only about 5 more minutes. I went maybe 8.
You did wonderfully, and I'm impressed that you didn't cough all that often. I think I coughed more than you did, and my mic was off. So, uh, Alan, have a drink. Take a look at the Q&A in just a moment, and folks, I'm thinking I need to run a technology Zoom class. It won't be for credit, but I'm going to put something together, and I'll go over everything so that when you all enter Zoom in the future, you'll be professionals with it. So, folks. The chat module is where we're placing the link for the evaluation. I've done it several times already. I'm about to do it again. Boom, there it is. What you do is you click on that link. When you click on that link, and I forget too sometimes. I know it's election season. We have new board members, and I get that. So we're here to help you out, folks. So when you click on that link, and this is what will open up in your browser. This evaluation here. So the evaluation doesn't appear on Zoom. Only the link to get to this is what we place into the chat. You click on that link, this opens up, you fill this sucker out, and after you hit submit, there'll be another screen after that showing hopefully a successful submission. And that screen has Alan's contact info, the link to download and save the slides. I'll go over all that. For those of you still having issues, after Alan does a bunch of the Q&A. I will share my screen. I will fill it out in real time and show any of you newbies who may be struggling with it. Alan, back to you.
All right. So I'm going to do my best, but I have a feeling that the usual blitz is what's going to cause me to have that coughing fit. So I'm apologizing in advance when that inevitably starts to happen. May, good to hear from you. Could you please clarify how interest earned on CERS and TRS reserve funds should be handled? Does the interest need to be deposited directly into each respective reserve account and maintained separately? Well, that interest is going to accrue directly to the reserve account. So it's not that you need to deposit it, it's already going to be there. My perspective is that it probably stays there because you can't use the funds that were deposited and accounted for in any different way. But you may want to actually talk to your accountant because that is not part of the reserve unless it's included in your actual SERS. So to go back a little bit and explain that a little better, when you have your structural integrity reserve study, it says here's the dollar figure that you need to account for every year. And the board gets to decide how you're going to account for that, how you're going to get the money. Then you get the money, it goes into the bank account, and that earns interest, is what May is asking about. So my perspective is that interest is not factored into the SERS calculation. So whether or not you're actually able to move that money, there's nothing that specifies in these statutes how you're supposed to do that. Now, whether or not you can contact your structural integrity reserve study specialist and have them give you the information, that might be the best way to go. You might just want to get a written opinion because this is a fiduciary duty issue. Anytime we're talking about SERS, I would get a written opinion from your independent condo counsel to determine how that should be handled so that that's something you can rely on, which, as Jeff might have mentioned, nothing we say today is legal guidance. And as much as I try to be 100% accurate, the slides are 100% accurate, my explanations are 100% accurate. It's not something that you're allowed to rely on as legal advice. We don't, even if we have an attorney-client relationship with your association, that doesn't mean that you can rely on what I've said today as legal advice.
Yeah, things are interpreted, can be interpreted differently depending on the situation, too. So it's very important you always contact your association counsel.
Yeah, including the word interpreted. Um,
Did I say that? Jeez, I need more
Twice.
coffee.
Yeah, that's okay. Betty asks, our structural engineer told us effective January 1st, 2027, two-story condos, 25 units or more, will have to have a SERS report. Is this true? Maybe your structural engineer is also a legislator, but I'm not aware of any proposal that's even on the table right now. And maybe I'm missing the proposed legislation, but it's definitely not something that is stated in Florida law as of right now. Whether that's going to go into effect, I candidly don't know, but I don't anticipate that that will happen because the reality is, over the course of the 4 years that we've had these SERS requirements, the requirements of who needs to get one done have actually been relaxed rather than, you know what, Jeff, you finally got me. Congratulations. Um, those requirements have actually been relaxed more and more each year versus being required to be more narrow or more broad. So I don't anticipate that being added, but I can't promise it won't. Um, Jonathan asks, I heard someone say the link can only be a year, but the original video recording has to be kept for 7 years. Is this true? No. The original video recording is kept for 1 year. The statute's pretty clear about that, Jonathan. So not a requirement to keep it for more than a year, period. Krista asks, will DBPR add knowledgeable enforcement staff to hold the management firms accountable to these laws? We've been hoping for that for a very long time, not necessarily for specifically accountability for CAMs, but just in general. I can't say that I have any reasonable expectation that that's going to happen. We always hope that they provide significant education or hire people that are already knowledgeable on these topics. It doesn't always happen. So, unfortunately, Krista, I can't say that that's a definite, let alone what I would expect to happen. Karen Beast, the official records, can they all be saved digitally or do we have to have a hard copy printed? So, you can save them all digitally in a condo and you can tell someone, and this is what I've been advocating for years. Hey, everything you're asking for is on our website. That is an appropriate response for a condo to a records inspection request. The problem is if they say, well, I don't have the ability to get on the website, not because I don't have a login, but because I don't understand how to use the internet, you might still need to provide a computer for them to review that. So, moving on. Ernest asks, units have two habitable stories but seem to fall under milestone inspection. Why? I could not possibly tell you, but if you're in Delray, it might be that it's not a milestone inspection requirement. It's more that it is I think it's 30 years in Palm Beach, maybe 40, that your buildings need to be inspected. It's a re recertification requirement that is separate and distinct from what's required by the milestone inspection laws. So that might be it. If you only have two habitable stories above ground, maybe someone miscalculated. That's all I can say. Jonathan, if the documents are on the homeowner portal and the office has the ability to print them, does a printed copy? I think I answered this one already. Yes, you can ask an owner to wait while you print it. You can also charge them for any copies that exceed 25 pages. Affidavits that go on the website, is that for the past 12 months? I believe the answer to that one is yes. Batya. Richard asks, must a board or committee meeting be in by video in addition to in person? No, you never are required to hold a video conference meeting. You always have the option, but if you choose to hold it primarily by video, then you have additional obligations, Richard. D, does financial reporting timing include condos under 25 units? That is all condos in Florida, so the answer is yes. Dominic, our portal includes all the financials for the year. Does the board still need to provide annual financial reports? Yes, because that is a separate requirement of the association. Now, I would look into whether you can provide just like a quick mailer rather than providing an actual copy, which you most likely can do, but you do need to provide notice that the annual financial report is available at minimum. Charles asks, how many years of year-end financials can a unit owner request? They can request 8,000 years. It's what you're required to maintain, which I believe is the last 7. How quickly must they be produced? Well, we didn't get into this because it's not a board certification class, but that is 10 business days is when you have an obligation to produce those records. Paper copies are electronic. If they're willing to accept electronic, that's fine. Can the association charge a fee if it's 25 pages or more? Yes. If not, no. And what I would suggest is that everyone have a records inspection policy that dictates what those fees are going to be, whether there's any additional review charges for management to go back and take a look at that stuff. If it's more than a half hour looking through archives, you can generally charge up to $20 an hour if the management contract allows for that, etc. So that is not the topic today, so I'm not going to go into detail, but I would suggest, Charles, if you haven't already taken a board certification class with our firm, that you do that because this is addressed, these records inspections are addressed in detail during that board certification class. Current asks, what if you only receive part of the records you requested and no checklist? Have they complied? No, technically they're required to provide the checklist, but realistically, that checklist doesn't really do you any good because 99% of the time, and I will say for my clients, I'm telling them it's just a checklist of the categories that you're providing, not the individual documents. And that's all statutory anyway. It's not really a benefit. I don't really understand, candidly, why the legislature put that requirement in place and what benefit was intended. Jeff, do any board members need to be at the physical location of a hybrid board meeting or can they all attend via Zoom? If it's a board meeting, they can attend via Zoom. If it's a member meeting or the annual meeting, to be more specific, they are required to have a quorum, a majority of the board there in person. Wendy asks, had annual meeting, but the video didn't work. Do we just state that in the minutes? Yeah, I mean, we've had this come up, Jeff. I know we've discussed this.
I
If the recording doesn't work, then, you can't produce something that doesn't exist. I would put not just state that in the minutes, but also put in an affidavit that you have done everything you can. The meeting was scheduled via Zoom, it was held via Zoom, but for some reason the recording didn't work. And that's the reason that that recording is not in the meeting, in the official records.
and I ended up putting in there the steps that I took to correct. That happened to me one time recently, and I also put in there the steps that I took to correct that from hoping it won't happen in the future. But with technology, you never know.
Thanks, Jeff. Uh, Janet asks, what's the guidance on meeting regulations for snowbirds? I'm not really sure what that question means, but having a hybrid meeting means that if they're out in New Jersey, New York, wherever they are snowbirding, that they can still attend. That's about the best I can do based on the way the question was worded. Barbara Miller, are you saying to hold a board meeting in person and the optional Zoom? Yes, that's exactly what I'm saying. And again, you asked about five board members. Can three attend by Zoom? Yes, unless you are talking about your annual meeting. The annual meeting, it doesn't matter how you're holding the meeting, a majority of the board members actually, let me rephrase that because you really only need a majority of the board members to attend an annual meeting, which is a member meeting, if you're holding it virtually and not having an in-person meeting with a virtual component. Michael asks, wouldn't a lack of quorum stop the ability to have the annual meeting, but wouldn't stop the election, which has no quorum requirements and only needs votes from 20% of the eligible members? Well, as I literally just mentioned, so great timing, Michael, the board is not part of the quorum except the fact that they actually happen to be members at an annual meeting. So having no quorum of the board at an annual meeting means jack. It doesn't mean anything because the quorum that's required at that meeting is a quorum of the members. Now, a majority of the members need to attend in person if you're holding that meeting virtually. If you're holding it in person, I don't care if none of the directors are there, as long as someone has been elected or appointed to preside over that meeting, you can still have it as long as you've got enough people to show up and actually vote.
Can I throw you a curveball? We've talked about this before, and I think you know what's coming. What if you word the meeting notice as the official meeting location is the Grand Ballroom in the East Wing, and for your convenience, we're going to provide a simulcast. So if you can't make it to the official meeting place, you'll be able to hear it and see it via Zoom. Is that official record, and does that need to be recorded?
So my perspective is no, it's not because the statute doesn't say it is. And Gus just asked that exact question, and I think about 25 people asked that exact same question in different ways. Again, I mentioned what happens when the majority of the directors are out of town. You hold the meeting in person and allow a Zoom component. You can avoid all of these requirements, as Jeff mentioned, by just holding the meeting in person and allowing everyone that wants to attend by Zoom. This is a loophole. This is what lawyers do. We find loopholes. We're not criminal lawyers, so we're not trying to keep people out of jail. Although now the legislature seems to think we should have to do that.
For that, you better call Saul, right?
Yeah, exactly. The legislature seems to think that everything that's bad in a condo should be criminalized, but the reality is this is something that the statute just doesn't address, so you can get around it. When most directors are out of town, if you're holding it virtually, you can't hold the meeting. And that again is only pertaining to your annual. It's not every meeting of the members, it's not any meeting of the board. Michael asked, in other words, a board member not attending wouldn't stop the election, it can only stop the meeting. Well, you can't have an election without a meeting. So, unfortunately, same answer. Susan, can a budget meeting be strictly Zoom with no way to physically attend? Technically, yes, because it's a board meeting. Is the board required to actually discuss the budget, answer questions, and explain before passing the budget? No, they are required to have the meeting. They have to discuss. They don't have to answer any questions, but they do have to allow you to ask the questions. But technically, because it's a board meeting, they can have a policy in place of how those board meetings go. And unfortunately, if they want to avoid any obligation to actually listen to what the members have to say, they can say that those questions are going to be asked after they've already voted. I don't like it, but it is something that the statute doesn't really prohibit. Shannon, we hold our meetings on property and we allow owners to attend via Zoom. We were told that the annual meeting that we're required a quorum of the board to be physically present, and my perspective is that is incorrect. We've talked about that at least 5 times during the Q&A today. And understand when I make that comment, I'm not blaming anyone. These questions were submitted when we were talking about it during the webinar. But
And not everybody can see everybody else's questions either, so it's cool.
right. After a budget meeting, how many days does the board have to mail out the approved budget? You don't have to mail it out. You just mail a notice. Basically, I think you have 30 days, but I don't see why you would wait any longer than doing it immediately. Dominic, what are the procedures if our management didn't produce adequate financials or for our auditor? We changed management and the previous management never sent the proper ending documents and didn't respond, causing us to have the new management reconstruct the financials. I mean, depends what your contract with the old manager said. You might have the ability to go after them for whatever it cost you to reconstruct those financials. But if you've got everything you need now, it's very unfortunate, but it might be just, what does the contract call for attorney's fees? I would run that one by your association counsel as to whether it's worth actually pursuing a lawsuit against your former manager because it might not be. It may be that you're looking at, $700 in management fees and just to get that lawsuit filed, you're looking at about 2 grand at a minimum. Right. You're not throwing money away if there's an attorney's fee clause in your management contract, but there's no guarantee that you actually get anything back. So, it's a questionable as to whether it's worth it. That's a board decision, and that's one that I would take up with your individual attorney.
Pick your
Gus,
battles like anything else.
yeah. Gus asks, is the SIRS 25,000 per item or total? If the association is responsible for sliding doors, is it for each door or all the doors? It's all the doors. Corinne, good to hear from you. Is the law only applying to funding of SIRS to get loans, or anytime the board wants a loan, do you need a majority? So that's actually something that attorneys are in dispute over. My opinion is it pertains only to SIRS. But I've heard attorneys saying now you need it for any loan and any special assessment because the law's not clear enough. I would be surprised, but I can't guarantee if a judge actually found that if your bylaws say you can get a loan for non-SIRS items, that you can't get it anyway. Can't guarantee. Again, that's one I would get a written opinion from your counsel if you can. David, isn't a structural integrity reserve study only required for condos 3 floors or more? Yes, but it's actually now 3 habitable stories. Desiree, do you know if there's any discussion underway about requiring engineering reports for structural maintenance or on condo buildings that are 3 stories or less? None that I'm aware of, and presumably that's because the structure is only 3 stories or less, and so the likelihood of truly catastrophic failure and, frankly, death is somewhat less. I won't say it's significantly less, but it's likely to be less than, let's say a 15-story building on the beach. So the short answer is nothing I'm aware of right now. Charles, what's the deal with pausing reserves with a majority vote for 2 years? It's only allowed if the association spending that reserve money on repairs during those 2 years. Yes, that's exactly what I said. Or can the condo just delay funding regardless? No, it has to be. There were 2 different reasons we discussed today. One was if there is an actual hurricane that makes your building uninhabitable. The other is if you are actually performing milestone required repairs. Not just repairs, but those required by your milestone inspection report. Is the 25K minimum also applicable to non-SIRS? No, you don't have a requirement on any random catch-all items if you are talking about non-SIRS components. So that's only structural aspects of your buildings. Mirtha asks, pooled reserve funds only require board member approval or vote, not SIRS. Yes, correct. To pool your reserves or reverse from a pooled reserve to a straight line only requires a board vote. Again, as to how you move the money around, that might require a member vote. I would get guidance from your attorney. Batya, if you're doing a 50-year recertification and can postpone the SIRS reserves until recertification is completed, you don't need to add SIRS to the budget. Correct. If you can delay it for that long, then I guess you wouldn't need it because if you don't have a SIRS, you don't have SIRS reserves. Pretty easy. Jocelyn, with the 115% rule, why can it be addressed for a change and the same things not included in an audit? I'm not sure I understand that question. We're only talking about how you're budgeting. We're not talking about what your financial reports show. Do I think that that's something that might be changed by the legislature to require significantly more for the $500,000 mark to reach an audit? No, I mean the audit is based on your overall revenue. I don't see that changing. I think that was the question that was asked. Marion, good to see you. Please clarify the signing of the affidavit acknowledging receipt of SIRS. Once it's signed, what do we do with it? It goes in the official records of the association. I would add it on the website because all affidavits now need to go on the website. So yes, Is it sent to DBPR? I don't believe that is required, but you're going to look online on their filing form. I don't think that it even asks for a copy of that affidavit. Deb asks, how do residents and owners get notified of the board's decision to require an evacuation? The answer is, however the hell the board wants to notify you, that's how they're going to do it. There's nothing in the statute that says how it needs to be done. That would be very helpful, but it's not there. Barbara, what to do with owners becoming candidates to run for the board and they don't follow the bylaws? That is not at all the topic today. So I'm sorry, but I'm going to skip it. And sorry that I read it out loud but didn't answer. But we have another 37 questions that have still been asked that I need to get to. So we had the milestone inspection and CEUs reports before the law was changed to exclude our condo of 9 connected townhouses. That was very Canadian of me, sorry. And I'm from New Jersey, not Canada. With only 2 habitable stories, we plan to continue with reserve requirements. Can we now add our very small outdoor pool into that reserve and fund that on a monthly basis into our protected or into our pooled reserves? Well, since you're not required to have reserves at all, or at least structural reserves, I don't see a problem compiling and pooling all of your reserves if you're not required to have them. So the board, even if you did need to have them, gets to choose what goes in each pool. If you, pardon me, don't have structural integrity reserves, you only have one pool. So you don't need a second pool and you can put everything in there as you suggested. Michael, exemption for CERS is only for family structures, or is it 4 or more or 4 or less families? As I mentioned when I was explaining it, it's 4 or less families that are 3 habitable stories or less that don't need to have this have CERS. John, can official records be provided via the condo website? I did announce after you asked that question that the answer is yes. Jeff, can association require all voting to be electronic only? No. The individual members need to opt into electronic voting or choose unilaterally to submit that vote via email now. Laura, I live in a condo that has 5 units. 4 are 2-story, 1 is 3-story. The 1 3-story unit is in the middle of the 5 unit building. Does CERS apply to the association for the 3-story unit? Yes, unfortunately, because they're all in the same building. I don't know how that works unless you just have another floor on one of the units. That'll apply across the board. Now, maybe this is a commercial building that doesn't require it because it's not residential. So that might be something to look into, Laura. Again, I would get some direct advice from your counsel. Batya asks, must we have electronic options for elections or can we keep it only physical? No longer an option to have only physical elections. You need to either do allowing electronic voting, even if nobody opts in, or the emailed voting. So you have to do one or the other, preferably the electronic voting because it's more secure, it's safer, and it's better. Susan, are pay apps for concrete restoration required to be posted on the website, or at least an account of money spent to date? I have no idea what that meant. I don't know what pay apps are.
Maybe applicate like online payment. I don't know.
Yeah, I mean, if you're talking about we've got a contract, it requires the contractor under the AIA contract to actually submit a request for payment. Those generally would be official records. I'm not aware of anything that says they need to be posted on the website. That is a bid requirement, not a payment requirement that I think you're thinking of.
And Suzanne, she's no longer on the call, so she's
Okay,
not here to
well,
clarify.
you didn't get that, but hopefully she'll watch the video later.
Yeah.
Can proxies be used to vote for directors in annual elections? Not in a condo. Federico, what are the consequences if a board cancels 1 or 2 or more annual elections and 13 months has passed since the last election? It depends whether they canceled or they're just choosing not to hold one. If they canceled it because there was a problem or because there was no quorum and they actually tried to hold the election but they couldn't because no one put their name in the hat, then no election was required, but they were required to hold the annual election, or I'm sorry, the annual meeting. So when people say annual election, they're really talking about 2 separate things. One is the meeting itself, the other is the election that generally is held in conjunction with the annual meeting. Now, the fact that 13 months has passed doesn't necessarily mean they're doing it wrong, but within those 13 months, they should have scheduled an election and an annual meeting, and they should have attempted to hold the annual meeting. If they haven't done that, then you can send them a demand to do it. And if they choose not to, then you do have some legal recourse. I can't really go beyond that because that would be legal guidance. All board meetings done by Zoom must have a physical location with a majority of the board. No, we mentioned that several times. That's not required. It's only at the annual, Bonnie. David asked, isn't a structural integrity reserve study only required for condos 3 floors or more? It's 3 habitable stories under the Florida Building Code. And yes. Deb asks, any consideration for adjusting safe harbor? Foreclosures take long. Not the subject of the discussion today, and I'm not aware of anything that the legislature is doing to help us out here. Batya, what if the CAM contract is older and may not have had the clause that I pointed to with, and I presume this is with respect to the special language and disclosures that now need to go in the contract, the special language that says we are going to comply with our statutory obligations. My perspective is that all management firms should be asking for an addendum that now includes that language. I think the argument that some management firms are taking is essentially that we didn't have to do that when we signed the contract, so we don't have to go back and retroactively do it. That is a Kaufman issue, not regarding governing documents, but regarding retroactive application of a statute.
No, I'm going to interject. I got a question in the chat. Can a cam drop off at this point? Folks, with any of our classes, the required material is the evaluation and staying on for all the slides. Q&A is bonus. You never, we would love for you to hang out, but the Q&A part, you never have to hang out for the Q&A part. Back to you.
All right. Deborah, good to hear from you. Can we direct owners requesting to visit the management portal to obtain and or must have hard copy on site? So for what you're required to keep the adequate copies that I mentioned, you should have copies on site. Again, just print it out in a binder and move on with your life. But for literally everything else, you can direct them to the portal for the most part. And if they say, I can't access the portal, then your response is, okay, you can come into the management office on this time, this date, this location, and we will provide the inspection. There's nothing that says you can't just put a computer in front of them and say, let me know what you want printed. Corinne, can the salary amount be redacted from the CAM contract if the owner requests to see it? Unfortunately, no. That is not something that is excluded from the official records of the association. And presuming you're asking about the CAM's obligation to provide it, there's nothing in the statute that says they don't have to produce that information. It's information that the association's members are entitled to know what they're paying the CAM. Carol, how many meetings a year does a condo is a condo required to have? Technically, 4 board meetings, and the annual is really what's required. Let's see. Susan, does a director or officer need to sign an affidavit of mailing the CEUs if it was completed in 2024 and mailed to everyone? My perspective is probably not, because that would be retroactive application of a statute. The other question is why you would refuse to do that if you can protect your association by just saying, hey, we took care of this requirement. I know that it's putting testimony in writing, so I can understand that perspective, but again, should be pretty easy to produce that and sign it. May, video conference as official documents, recording hyperlink needs to be available for how long? 12 months. And best practice on how to save it again. My perspective is just put the Zoom link in a Word document, PDF it, and put that on the website. That's how to save it. Federico asks, if the condo has used a plumber, for example, before, does the board have to have 3 bids every time he's hired for a new job? Depends whether that plumber's work is going to exceed the threshold of what requires bids. Now, if the plumber works with the CAM or the management firm, that's $2,500. If not, then depending whether you're in a condo or HOA, it's going to be either 5% or 10% of your annual budget for each time the plumber comes out. So I can't answer directly without more information. Barbara, what to do when owners filled the candidate to run for the board, but they ignored the bylaws and rules and regulations? Again, can't answer that. What do you want to do? That's up to the board. I would ask for guidance from your counsel, but realistically, the fact that they have not followed your rules is generally not a reason that you're authorized under the Florida statutes to keep them off the ballot. Barbara asks, what to do if the board wants to have closed meetings often? The board can have closed meetings only in 2 instances. One is with counsel to discuss potential or ongoing litigation. The other is to discuss employee matters. Now, a lot of people want to have these closed meetings. What I would suggest is you have less than a quorum of the board meeting to discuss these issues and decisions are not made. That is not a board meeting. It doesn't have to be noticed, etc. But if you want to have a closed meeting, it needs to be for one of those two reasons. Joanne, is the threshold reserve study adequate or must a reserve study include all three methods, component, pooled, and threshold? No, threshold is the overall concept. You're also going to have either straight line or pooled. So this is not three different methods. Threshold is a requirement, period, and your actual reserves will either be component or pooled. Stephen, what if a board member's spouse or child offers services to the community without disclosure? However, the CAM is aware. That would be a conflict of interest, and you can talk to your attorney about what you can do about that. Keep in mind, it is not the individual members of the community that generally have the right to go after that. It's the association itself through the board.
And we have a class just on that stuff.
Right. Conflicts of interest is a separate class that we do teach. I don't know if we've got one coming up, but I believe I'll be teaching it at the upcoming CAI trade show on March 5th in Orlando. So if you want to get that information and you're on the board, might be something to sign up for. I believe it's free for board members to attend. And CAMs, if you're in Orlando and not already attending, shame on you. Just kidding, but I hope to see you there. Just to clarify, Terry asks, annual meetings, a quorum of board members must be physically present in person. Correct, unless you're holding the meeting in person, which is, I think, a little bit crazy, but not something the legislature accounted for. If you're holding that meeting in person, the members of the board can choose to attend virtually or not attend at all. If you're holding it virtually, you need to have a majority of the members. Of the board members, I'm sorry. You can charge for copies only if more than 25 pages, Corinne asks. Yes, that's very clear under the Florida statutes. And keep in mind that that also requires, if you want to charge for it, that you have a records inspection policy or your management contract that says you're going to charge that amount. David, isn't a structural integrity reserve study required for condos 3 floors or more for probably the 15th time today? Correct, but it's habitable stories, not just stories. How do you obtain the format for the website posted affidavit? Your attorney can prepare one for you, David, or you can just go online and find an affidavit and prepare it yourself. I would recommend that the attorney prepare it for you so that it's one, accurate to your representations being made in an affidavit, meaning your written testimony, but also two, sufficient to meet the requirements of that statute. Desiree, does the management company's homeowner portal website satisfy the state's requirements? Depends on your management company because there are certain things that need to be available right on the front page of the website. 99.9% of them meet these requirements, but I can't say that all of them necessarily do because I don't work with every management firm in the entire state of Florida. Now, if you want to make that happen, feel free to reach out to me. But as of right now, there are plenty that I don't work with and the firm as a whole doesn't yet work with.
Alan, the final question, even if more come in at this point, because we only have 10 minutes left. All right.
Okay.
There's the one time stamped by Susan at, I think it's for you, it's going to show 11:46. That's the final one. Any ones that come in after I said this right now, that's it. Back to you.
Okay. We conduct hybrid meetings. Please confirm, Terry, whether this is correct. Annual meetings, a quorum of board members must be physically present, but all other meetings for the 50th time today, correct. The board members do not need to attend at all, for all I care, for non-virtual meetings. Federico, are monthly financial reports required? No, you need annual financial reports. I don't know why you would want to not have monthly financials so that you actually know what the hell's going on in your community, but I don't know of any statutory requirement to have them. Every management contract I've ever looked at says that a monthly report will be prepared by roughly the 20th of every month for the previous month. Corinne, do they have to put in writing what was not provided in the records request? Again, that's not the subject of this class, but the answer is yes. But again, it can be just the categories of what was excluded pursuant to statute. Damaris, good to hear from you. What the difference between a board meeting and a member meeting? Who gets to vote? That's the big difference. A board meeting is a decision that the board gets to make and only the board gets to vote. The members get to speak, but they don't get to make any decisions. A member meeting, the members are voting on something. That's usually going to be material alterations, amendments to your governing documents. the election, and maybe one or two other things that are a member meeting. Everything else is a board meeting. Laura asks, is providing documents by printing off the computer acceptable, or do you need to have some already printed? I don't know if you're talking about a records inspection, which you wouldn't have to have anything printed, or the things that you're required to have adequate copies, which in my opinion should already be printed. So I think I answered both questions there. Alberto, I have a candidate for the upcoming election who's asking management to disclose all owners' contact information, presumably to actually provide all the contact information so that this person can contact everyone. The candidate says that we're interfering by not providing phone numbers or email addresses. You provided the name of list of names and mailing addresses, but not phone numbers or email addresses. You do have to provide email addresses that are designated for purposes of receiving notices from the association. That functions the same as a mailing address. But other than that, I think you're probably doing it right. And that might be something to get direct guidance from your attorney because that attorney is going to be the one dealing with an election challenge if this owner gets pissed off enough to actually challenge the election process. Jocelyn, with the 115% rule on budgets, etc. Oh, we already addressed this one, so I'm not going to address it for a second time. I guess she copied and pasted, thinking that I might not see it. George, no privacy concern putting the affidavit of late assessments on the website. No, because frankly, the reality is that every owner's ledger is subject to a records inspection request anyway, and you're not necessarily including the actual notice of late assessment unless you're attaching that to the affidavit. Deborah, we had an annual meeting. Am I correct that we can't go back to an April date? We got behind with the cancellation of online voting services. Deborah, I have no idea what this means. Please text me. Mary Carmen, if a budget meeting was scheduled and all board members appeared, but the CAM didn't show up, can the budget still be approved? Yeah, the CAM never has to attend a meeting other than that it's their obligation. That doesn't impact the validity of anything that was done at the meeting if the CAM's not there. Corinne, is the secretary responsible for records on the website or the CAM? You need to refer to your management contract. The secretary is responsible, but most management contracts are actually going to say that the CAM has taken over that responsibility. Batya, if the condo has to prepare an election portal for digital elections, well, you won't have to prepare an election portal. Your vendor will do that. The selected computer engineer will be a relationship with the management. How do you disclose this? Don't do it. The association is not a vendor and should not be creating its own company for purposes of electronic voting. You should be using an existing electronic voting vendor that's reliable and reputable. So I'm going to skip that question. No offense, Batya. Corinne, can any information be redacted on official records? There is an entire list. So again, I would suggest checking out a board certification class. We go through that, but frankly, you might just take a look at the Florida statutes. Each of them have an entire list of what is excluded from what needs to be produced, and all of that needs to get shut down. Was that supposed to be the last one, Jeff, or do we have a couple more?
No, it's three more. It's ending
Okay.
with Susan at at
All right.
11:46.
Perfect. Carol, does the accounts payable accounting report need to be on the website? No. Barbara, thank you for responding. I know.
Oh,
Okay.
thank
Well,
you for the
thank you
kind
very much,
words.
Barbara. Nice comment. Susan, is electronic voting for elections, or does this apply for other votes by membership like special assessments? So, if you're asking whether you can use electronic voting for everything that the members get to vote on, the answer is yes. If you're asking whether the email voting is required for anything other than an annual meeting, the answer is no. And since we skipped one, oh, you know what? It looks like the next four are just a thank you.
No, we appreciate everybody.
Yeah, everything else is just a thank you. So, fortunately, this is the first time in a while we got through everything. Thank you all for your time, especially the over 270 of you that are still here after almost an hour after we finished the main presentation.
Yeah.
So Jeff, I'll turn it over to you in just a second, but I do want to thank everyone, especially those who are still here. Thank you to everyone for coming. I hope you got a little bit or preferably a lot out of this. Thank you for bearing with me and Jeff as my voice sounds awful and I've been coughing all day, but I hope everyone enjoyed. Thank you all. And if you need to reach out or just want to reach out, my email address, thank you to my partners, is as@kbrlegal.com. That's usually going to be the easiest way to reach me because I try to spend as much time as possible in the office, but it doesn't always happen.
And thank you for not having a middle name of Stephen, by the way. Just
Yeah, well, you obviously haven't seen my most recent business cards.
and folks, just for those of you that are still here, you witnessed history today. A little bit earlier, I've been trying for 3.5 years to get Alan to crack a smile and giggle during the class, and today was the day. Mark it on your calendars. We're going to have a party next year on February 13th.
Cheers.
Hey, no, I'm glad you're smiling, feeling a little bit better, and
You and likewise.
you take care, and I'll talk with you soon. All right.
All right. Thanks again, everyone. Y'all have a good one.